Okay. Hi, everyone. This is Arjun. I'm the head of the Knowledge Transfer Program at Carnegie, India. It gives me great pleasure to announce a new initiative, which is our Tech for Thought series, which is a series of 6 workshops that we're delighted to partner with Plaksha University to bring to you. The primary aim of the Knowledge Transfer series at Carnegie is to go back to the fundamental of first principles, something that we tend to ignore all too often. And we ignore our own peril of technology, regulation, and state capacity. Today's session is called What is Data, and will be hosted by Vrinda and Udbhav. Vrinda Bhandari is a Rhodes Scholar who graduated from Oxford with a double master's in law and public policy and received her undergraduate degree from NLS Bangalore. She is a litigating lawyer in Delhi and specializes in the field of digital rights, technology, and privacy. She is also the off-counsel to the Internet Freedom Foundation. Udbhav Tiwari is a non-resident scholar at Carnegie, India, who works towards keeping the internet open, secure, and accessible by advocating for progressive regulations in the technology sector. He is also a public policy advisor for Mozilla, where he primarily focuses on data governance, content regulation, connectivity in the Asia-Pacific region and beyond. So the session is going to be sort of divided into 2 parts, where Vrinda and Udbhav will each give their piece, and then they're going to move into a conversation and allow you to come in with your questions and answers. All the attendees are welcome to use the Q&A and chat functions to share their questions. Thank you everyone for registering for this session, and Vrinda, over to you.
Thank you so much. So I just wanted to say before we start that we would really love it if you ask us a lot of questions. No question is too stupid, no question is too dumb. So I'll be speaking for around 20-22 minutes, and Udbhav will then be speaking for 20-22 minutes. And then we really want to have an open and flowing conversation. So, and even during the presentation, if you have any questions, etc., please do ask us at the end. We really want to encourage kind of a discussion, open discussion. So yeah, with that, I'm just going to share my screen, and this is going to be the background for the presentation. Okay, great. Can everybody see my screen?
Yes.
Sorry. Okay. It's just saying my screening. Just hold on. Yeah. So this is on what is data. This is, as Arjun pointed out, a sort of fundamental 101 on kind of how to understand data, how to understand privacy. Data, very simply, is any text, any audio, photo, videos, location, numbers, even opinions, about a certain characteristic of a person. So the fact that, XYZ is hardworking, or, this is my inference about her character. All of this is data. As long as it can be presented, as long as it can be processed, it can be communicated, it's data. We broadly understand data in the tech sphere into 2 buckets. So you have personal data, which I'll go into, and personal data is further categorized into sensitive personal data and critical personal data. So if you see the graph on the right, personal data is your biggest superset. Within that is included sensitive personal data. Within that is critical personal data. So all sensitive personal data is personal data, for instance. Then the other bucket is non-personal data, which can include things like traffic patterns. It can include things like soil analysis. Udbhav will be dealing with non-personal data in his presentation, so I'm going to leave that out for now. Now, when we just talk about what is personal data, so any information that relates to a natural person who can be identified directly or indirectly by that information, including any inferences drawn from that profiling. So this is very important. So when we talk about personal data, a lot of these definitions are from the Personal Data Protection Bill, which, as you all know, is not law in India. Maybe in the Q&A, if you're interested, we can go into a detailed history of how the PDP bill has come into being, kind of what has happened in court during the Puttaswamy litigations. I was lucky to be involved in the 2nd round in terms of the Aadhaar litigation. So if anyone has questions on that as well, I'd be happy to answer. But the Personal Data Protection Bill that we have, which is our draft bill that is before Parliament, that defines personal data in this format. Now, when you think about personal data, think about it in the context of a direct identifier. So something that will immediately tell you that I am Vrinda Bhandari, or that this is my address, this is my phone number, this is my email address. So something that directly identifies me or any attribute about me. Now, indirect identifiers are things like your IP address or cookies. So these in and of themselves may not identify me. So if you just see an IP address or a cookie, you may not know that it's me. But when combined with other information, it can lead to my identification. So that's why even indirect identifiers are considered personal data. The PDP bill also talks about this idea of inferred data. So any inferences that are drawn for profiling purposes will also constitute personal data. So think about inferred data from the perspective of any characteristics or insights that you have generated about me. So for instance, when we have Apple watches, right? So Apple is looking at your health data, or any of the IoT wearable devices like Fitbit, which looks at your wearable data. So, it notes your heart rate. It knows how many steps you take. So from that, it may generate a certain insight about the user. So, Vrinda maybe walks 10,000 steps a day, and, this is her general heart rate. This is her general health profile. All those insights that even I may not know about myself are also inferred data. So that would also, for instance, constitute personal data. Something like a data trust score. So, if you're applying or any sort of trust score, really, if you're applying for a loan, sometimes, you have your CIBIL scores, and, some of that data about whether I'm credit worthy, whether it's worth lending to me, those will also become inferred data and hence personal data. Now, sensitive personal data is, sorry, I'm just trying to see. Yeah. Sensitive personal data is essentially personal data that relates to your finances, your genetics. So finances like your bank accounts, your bank details, transaction account histories, your genetic data. So things like your blood sample, biometric, iris, fingerprints, health data, my medical records, my COVID status, for instance. Official identifiers. So things like my passport number, my Aadhaar number, my sex life, sexual orientation. Caste or tribe is also considered a sensitive personal data under the PDP bill, as well as my religious or political belief or affiliation. Now, interestingly, passwords are currently defined as sensitive personal data under the information technology rules. Under the law that currently exists recognizes passwords as sensitive personal data, but the draft law, the PDP bill, doesn't include passwords within the ambit of sensitive personal data. So as you'll see, sensitive personal data is that data that has a higher risk, that requires a higher protection because of the characteristics of the data. So this is considered data that could be used in a manner that is harmful to me. So for instance, if I'm discriminated at work because of my sexual orientation, that is the reason why my sexual orientation is given a higher protected status. If I could be discriminated based on my health parameters. So for instance, when I'm applying for insurance, a decision is taken based on my health parameters. Again, that's the reason there is special protection given to sensitive personal data. And when companies process this data, when the state processes this data, there are often certain limitations that apply. Now, just thinking of two examples about what is sensitive personal data. So consider a digital lending app, and that if that wants to assess the creditworthiness of a potential customer. So amongst the data points that they may use credit information, transaction history, loan repayment details. All of these would constitute financial data. What if it also reads my transaction SMSs and my debit alerts? Would that also be considered financial data? And hence, will the app require the higher level of protection of explicit consent before reading an SMS? So that's something I'd like you to think about. You would imagine that anything that constitutes financial data and anything that informs the company or the app about my financial status will also include my transaction SMSs and debit alerts. And that's why that should also be sensitive personal data. Now, what is very interesting is when we talk about caste or tribe and do family names or your surnames. In many cases in India, especially, your surname will reveal your caste. So if the question that is very interesting and that arises is, does your surname constitute caste data? And how do companies have to comply with the additional obligations when they are processing data? And I believe, and we can have a further discussion about this, that the context should matter. So if for instance, you have an educational institution that's reserving certain seats based primarily on your caste, and then your caste data is something that they will have to treat as sensitive personal data, or if there's a matrimonial website that's looking at your caste data, then of course, and looking at your name as the basis for your caste data, then again, that is something where because of the context, it would require a higher level of protection. But if a company is just creating a general employee profile where they have the names of many, many employees, and one of those names incidentally may also reveal caste, I believe in that context, that caste data would not be considered sensitive personal data. Now, there is nothing in the text that necessarily supports this interpretation, but I believe that that is the only sensible way forward, because otherwise companies will have to treat all your name, which is essentially the information that every company would have or the state would have, as sensitive personal data, and would have to comply with the additional obligations under the Act, which would make it unworkable. What are these additional obligations? So if you are processing any sensitive personal data, so assume a company is processing any sensitive personal data, it requires the explicit consent for processing such data from me as an individual user. So if if a company is processing my health data, if a bank is processing my financial data, they need my explicit consent. Now, what is explicit consent versus just general consent? You can think about it in three formats. You can think about it from the idea of heightened notice. So they inform to you very clearly what is the purpose of your processing. So they will say, we are using this data for the purpose of assessing your credit worthiness. They will inform me that very, very clearly. They will also have to have heightened clarity so that there is no room for any other sort of interpretation. It has to be very clear, very simple. And there should also be specificity. So for instance, it should say that this processing is being used, and we believe that this data may be used to make a certain decision about you. So it should also inform me that it should provide me that additional specificity of how that information about me might be processed. So these are the three sort of categories of explicit consent. The other obligation under sensitive personal data is that all sensitive personal data must be stored in India. So it must be stored in India. I'm so sorry. I'm trying to see why it's not going back. Yeah, all sensitive personal data must be stored in India. It can be transferred abroad, but only after you take the explicit consent of the individual and only pursuant to a contract, or if the country is a whitelisted country by the regulations. So this becomes important because you may have read in the newspapers about the data localization debate, and this essentially is the data localization debate. Personal data can be stored anywhere, but sensitive personal data has to be stored in India and can additionally be stored abroad. We can discuss later in question answer sessions what are the law enforcement reasons for this, what are the privacy concerns that arise from this. But there are certain, those are issues that can be discussed. Now, interestingly, also sensitive personal data cannot be processed without the consent of an employee for employment purposes. So things like biometric attendance, many offices have biometric attendance when you enter. Under the PDP bill, you would require the explicit consent of an employee if you actually want to allow them to do attendance via biometrics. And if they don't consent, you have to provide them with an alternative of like your manual attendance registers. So this is going to become very interesting if it comes into play and maybe change a few things from an employment perspective. We can again discuss later whether context would matter, and would the similar requirement be for biometric access to top secret nuclear codes? Would that also require consent, or can I just say no consent? And as I said, we can discuss later. There is a certain reasonable purpose exception that's built into the PDP bill, and maybe this will come into that. There are some other obligations when you're dealing with sensitive personal data, such as the requirement to conduct a data protection impact assessment. If a significant data fiduciary is undertaking large-scale profiling, you have to have certain codes of practice to be issued. So these are the obligations of sensitive personal data. Critical personal data has not been defined in the bill, and but is widely expected to potentially include things like, say, personal data, sensitive, personal data or health data about constitutional functionaries. So maybe the Prime Minister, the Chief Justice. And that data can only be processed in India and can be transferred abroad under very, very, very restrictive conditions, such as like a health emergency, or if the central government allows it. Now, who are the actors in a data ecosystem? You essentially have three actors. You have a data fiduciary, and so that is the company that is, or the state can also be a data fiduciary that determines the means and purpose of processing individual data. So if you think about an accountancy firm where you're giving your, the clients of that firm, the accounts that they deal with, all the financial transaction, that company, or your chartered accountants, like the CA firm that does all your accounts, would become the data fiduciary in a context. If I go to a bank and I have a banking relationship, my bank would be my data fiduciary. A significant data fiduciary is essentially an actor. They are data fiduciaries, but they are classified by the regulator as significant data fiduciaries because of the volume of data they process, because of the sensitivity of the data, based on turnover, the risk of harm, any use of new technologies, or any other factors. So think about big companies such as Facebook or WhatsApp. So based on volume, we expect that they would be classified as significant data fiduciary. Think of any company that's in AI automated technology, or think like a company that's using facial recognition technology to process, certain, maybe for some law enforcement purposes. So these may be classified as significant data fiduciaries. You then have a guardian data fiduciary, and these are data fiduciaries that basically deal with children's data, and they process large volumes of children's data or operate online services which are targeted at children. So think of all your edtech websites, things like Byju's, things like all your coding apps that are there, things like your YouTube for kids, for instance. So YouTube would be maybe a significant data fiduciary, but YouTube for kids would be a guardian data fiduciary. There are a lot of obligations and restrictions on guardian data fiduciaries under the PDP bill. They are prevented from profiling, monitoring, or targeting ads for children. We can again discuss how this would work in practice. What would this mean for schools? Like think about schools and attendance and your report cards, right? Like what would happen in those cases? So these are also some things to think about. The second actor is a data processor. So data processor essentially processes personal data only on behalf of the data fiduciary, and it acts as per a contract and the relations only, the conditions given only by the data fiduciary. So your cloud service provider, things like your Amazon warehouse services, all these companies, host their data on third-party websites. So those third-party websites like Amazon warehousing services would become data processors. We can also talk later about how the same company, so like AWS, can be a data processor, but for its employees, it would be a data fiduciary. So the same entity can be both. And data subjects are people like you and me, natural persons. So these are the actors in the ecosystem. There are certain additional obligations if you are a significant data fiduciary. I am going to skip over that in the interest of time. But essentially, it involves then having to conduct data protection impact assessments, having data auditors. There'll be a data trust score, maintaining up-to-date, data records, appointing a data protection officer, registering with the regulator. Now, consent and exceptions are also important. So all data, the primary basis of processing any data under the bill and under our law is after you get clear, informed, and specific consent. So consent must not be bundled. You can't, and I'll show you some examples where I'll elaborate this. More importantly, no goods and services can be denied to an individual if they do not consent to the processing of data when the processing is not necessary. So some of you may remember a Chios example where Chios had introduced, facial recognition technology at certain outlets if you were going to go and order a product. Now, in that case, my facial recognition technology is not necessary for me to, it is not necessary for me to have a facial recognition technology processed if I want to go buy tea. And so in that case, I am allowed to say no. There are certain exceptions, which I'll also go into. So this is an example, if you can see the screen, where you have where you have separate consent. So I have read and accepted the terms and uses of service and privacy policy. This is one consent. And then I have the option of saying Adobe may keep me informed via email about products and services. So I have the option to say yes for the standard terms of use consent, but no to the marketing consent. And this is the right way under the PDP bill. This, on the other hand, is the wrong way. I cannot say that I will accept the terms of use and privacy policy and would like to receive weekly newsletters, because this is bundling the consents together. There are various exceptions to consent, which I won't go into, but they basically involve, functions of the state, compliance with law, legal orders, emergencies, employments, reasonable purposes. In these cases, you don't have to take consent, but you still have to comply with all the other obligations. Given the shortage of time, I'm going to sort of maybe just really kind of read out these headings, and we can discuss them if there is interest in the conversation later on. This is about how privacy fits in to a larger framework. So data is important because data is an identifier about me. But privacy is really what allows me to think and be freely, to act as my natural self without someone observing me. Privacy is contextual and it's relational. So I may share something with Udbhav because him and I are friends, but that information can still be private vis-a-vis me and you, the audience, because you and I don't want to share that information with you. So say I share my sexual orientation with Udbhav, I can still maintain that privacy qua you. Just because I share information with one person doesn't mean I lose that right to privacy for everybody else. There are lots of interesting, complicated questions about privacy in public spaces, privacy of like my data if it's uploaded on Facebook. And so those are again questions that we can go into if there's interest. Puttaswamy is a 9-judge bench of the Supreme Court that said that privacy is a fundamental right. It grounded it in dignity, in autonomy, in choice, self-determination. It talked about the dangers of data mining, both by the state and private actors. Very importantly, it said privacy is not an elitist construct. And I think this is something many people feel, oh, poor people don't care about privacy. And they actually rejected that argument. There is a lot of interesting literature which supports this argument that actually people do care about privacy. Women especially, care about privacy possibly even more because, their access to the world is often regulated through their cell phones. And that's another interesting area of discussion. There are also negative and positive obligations emerging from this recognition of privacy. So the fact that the state cannot take away my right without a certain law, without following certain procedures, whereas they also have a positive obligation to ensure that they create conditions for me to enjoy this protection. Privacy can be invaded by various ways. So, you can do it through a physical means, so ideas of bodily integrity. So when I'm like in the Aadhaar context, when I'm forced to give my biometrics, that is a violation of bodily privacy. Informational privacy is when someone takes unauthorized use of my personal information. So, sometimes if that data is taken without my consent. Privacy of choice or autonomy, when something is made mandatory. So when Arogya Setu was made mandatory for a brief period, it violated my privacy of choice. And mental privacy, so things like the use of narco analytics, on my mind, that violates mental privacy. There are also ideas like decisional privacy. So if you think about like 377, who can I have sex with or who can I marry? All of those are issues. It's important to remember privacy is not absolute. So my privacy right can be infringed, but it can still be justified by the state if they follow, if it is proportionate. So that's very important to remember. It's also important to remember that, and maybe if there's interest, we can discuss this later, that just because I have nothing to hide, so this argument that, oh, if you have nothing to hide, privacy is only for terrorists and like normal people don't care about privacy. And I think it's very important to dispel that notion. No one would like it if somebody came into a house when we were, say having a bath, if we were talking to a friend, so just, and like Edward Snowden puts it really well, that saying that I don't care about privacy because I have nothing to hide is like, I don't care about free speech because I have nothing valuable to say. And so that's also very important to kind of reject that argument. And finally, why does it matter when there is a violation of privacy? It matters because it creates a chilling effect. If you see what happened with the Pegasus, whether or not you were under surveillance, the fear that one may be placed under surveillance creates a chilling effect, and it may result in self-censorship, what we are putting online, what we are sharing with friends. We need privacy to have breathing space, to just survive and to thrive, to think freely. There are a lot of privacy violations don't impact people equally. Poor people are often, historically marginalized people, poor people, vulnerable groups are often discriminated unequally based on violations of privacy. The impact on women is more severe when we talk about ideas of consent and bodily integrity. So when you have issues like revenge porn, which is actually incidentally the wrong terminology, it should be a non-consensual sharing of any sexual images, etc. And just finally, sort of talking about the importance of privacy from state and non-state actors and why we should care. I think very simply, this is the idea that yes, we have to absolutely care about privacy from private actors. But the reason we have to be, and that's because the reason we have to be more concerned about the state is primarily two things. Any relationship with a private company is based on consent, choice, and control. Even if it is illusory or even if it's not great, the relationship is essentially premised on these three paradigms. Whereas with the government wields much more influence in our lives. They can very simply prosecute us, punish us, place us under surveillance, intimidate or harass us, and they can put us in jail. The monopoly of power enjoyed by the state is why we have to absolutely be concerned even more about privacy from state purposes. Surveillance today, I'm going to skip this right now. We can discuss this later, but the idea of how change in technology has changed in surveillance. And so maybe we can have a discussion about this later, and how all of this has meant that we need a law. And Udbhav will actually be speaking about that in a lot more detail. And the reason for that is a simple recognition of a fundamental right to privacy is not enough. We actually need the tools in place to operationalize this right. We need to have a data protection law. We need a data protection law not only to take action against the state, but more importantly, to take action against private actors. So for all of these reasons, I think we need a law, and Udbhav will probably discuss that as well. I'm happy to come back to any of these discussions later on, but thank you so much. Udbhav, over to you.
Thank you so much, Vrinda. And I thought that was a fascinating presentation and really laid the groundwork for a lot of the fundamental questions that I'm really looking forward to discuss in the rest of the session, but that I will also cover from a slightly different perspective, like in the course of my sort of like 20 minutes, where I broadly hope to firstly talk a little bit about what has happened in India, like when it comes to the question of regulating data in the last, say, approximately 2 decades at a very high level. Now that Vrinda has helped us understand some of the sort of like conceptual ideas behind data regulation, I thought I could look a little bit at the history and the politics behind those questions and the ways in which they've played out in Indian polity. Secondly, sort of talk a little bit about the data protection bill, which again, Vrinda has gone into in detail on certain aspects, but what I'll try to do is provide a little more of a high level analysis of like what's good in the law, what can be better in the law, how is the rest of the world looking at that law. And finally, I'll close by talking a little bit about non-personal data and what that even means, and ultimately giving some like high level trends and sort of like setting expectations for what we should expect to happen when it comes to the realm of data governance in general over the next 2 to 3 years in India. So, which is why this presentation is called Regulating the New Old Frontier, because in many ways, some of the questions that we've been grappling with are very old questions that have played out in society over the course of centuries, sometimes even millennia. But data and the idea of digital information being like, and the processing power that entities now have and the sort of rapid impact that it can have on people's lives, I think are some of the things that make these questions new and interesting. And that's essentially what data governance is fundamentally about. So, like, I mean, to start off a little bit around the historical context behind data governance in India, right? Like, so India has the Information Technology Act, which was first passed in 2000, and since then has been amended a couple of times with different pieces of information. But it wasn't until the year 2008 that India had any sort of a law that spoke about the idea of privacy or the idea of data protection in the context of information technology, right? So like Vrinda has alluded to, the Puttaswamy judgment, which the Supreme Court passed in 2017, really did say many things about how privacy as a back and forth between state and non-state actors is something that's as long as India has sort of been around, even before our independence. But I think the idea of consent, the idea of processing consent digitally and the processing of digital information are things that the Indian government only really sort of started grappling with in round about 2008. So, which is why the current legal framework in India that Vrinda alluded to are essentially these rules under the IT Act, which are called the Information Technology, Reasonable Security Practices and Procedures, and Sensitive Personal Data or Information Rules, which is quite the mouthful, but essentially are a very basic set of like 3, maybe 4 pages of rules that lay down very, very low-level obligations on what an entity can do in order to take consent and what sort of obligations they have towards their users. And but until that time, however, like the general thinking in like India was that one of the primary ways in which the information technology sector was growing was this idea that we were outsourcing many of our business sort of like processes. We were serving as the place for many processes to be outsourced all over the world, specifically in English language sort of speaking countries. And that data protection regulation may serve as a hindrance to a lot of that growth and technology and development. And that's an argument that was sort of made in the late 2000s and in the very, very early like 2010s for whether India should or should not have a data protection law. But there was some consensus that like this really needed to be an issue that people needed to focus on. And that happened in, let's just say, between 2008 and 2009. And then in 2009, the first concrete move by the central government to really look at how should like privacy and data protection be regulated in India was actually kicked off because of the Right to Information Act. So the Right to Information Act is a law that allows individuals to ask questions to the government of processes, programs, budget expenditures. And India's Right to Information Act, despite some of the very recent changes, is one of the strongest sort of like information disclosure laws in the world. And one of the fundamental ways in which that many times conflicted with personal information of either government employees or government workers was what primarily motivated the Department of Personnel and Training, which actually hires who gets transferred where in the IAS or other UPSC services, for example, to actually start talking about the data protection law. And they put together this roundtable, and there were a bunch of conversations around what a draft law at that point would look like. And this draft law was leaked to the public and led to a lot of conversation. But ultimately, that was pretty much, like, I would say, the first real move to having a dedicated data protection or privacy law in the country that didn't really go to too many places. Following that, by the time 2012 came around and Aadhaar as a project had really started to sort of like kick off in some of its initial stages and had a couple of million, if not triple-digit million people already on board, there was a lot of pressure upon the government to like fundamentally look at coming up with the data protection law because of the concerns that civil society was raising around the Aadhaar. And that's what fundamentally led to what is known as the Justice A.P. Shah Committee, right? And this was a committee that was under a retired Bombay High Court judge, Justice A.P. Shah. I hope I'm getting that Bombay High Court judge bit right. And that judge and that committee essentially came up with a very, very expansive report that looked at some like lots of obligations around like the high level like principles for data protection, and they came up with a set of like approximately 9 principles, and they were in the process of really coming up with a law, but like that process, because of the sort of changes that took place at the central government level in 2014, but also because of like I think a change in priorities and generally politics didn't really take off. And finally, there was this sense of like when the crescendo around the Aadhaar really started like picking up, and there was some cases in the Indian Supreme Court that fundamentally like challenged the validity of the Aadhaar and many aspects of it. That the government also, the new government at that point in time, that's still currently in power, kickstarted this like process of a new like committee, also headed by another formal judge, Justice Krishna, to create a new data protection law. So everything that Vrinda spoke about in the context of like provisions in a law, classifications, are all things that actually fundamentally come from this draft law that was passed in 2018, and it's and that committee that was set up in 2017, and everything that, and arguably the law that India is going to get when it comes to data protection and privacy, hopefully by the end of this year, maybe early next year, is fundamentally going to be the one that is shaped by this committee's work, right? So just as a context, you can see that there have been many stops and starts in India's journey to data protection and to data governance. Some because of changing political realities, some because of like a change in the outlook of the Indian industry. So, for example, in the sort of 2012 report that Justice A.P. Shah Committee came up with, it is widely understood within the sort of like broader public policy space that many of the companies in India that traditionally sort of thought that data protection or privacy may hinder their growth prospects, specifically in the outsourcing sector, actually started advocating for there to be a data protection law, because they believe that that certainty that the law would provide would allow them to do things like get adequacy, which is when another country says your data protection laws are as good as ours in a certain way, and therefore data can flow between those two jurisdictions. So they wanted that for the European Union, which at that point in time was at the verge of passing the GDPR. So there are like people have changed roles, broader motivating factors at the end of the day have broadly, however, I think still remain the same. And that's some of like the context behind the at least governmental efforts towards India having a data protection law. That's changed a little bit. That's like one interesting, I think, like aspect is that there have been 2 civil society organizations, the Internet Freedom Foundation and the broader sort of like Save Our Privacy campaign, as well as the Center for Internet and Society, a think tank in Bangalore, that have attempted to create publicly sort of like a consultative draft laws, or almost shadow laws, you could say. So you could think of it as a law that's created not by the government or a government committee, but by non-profit entities or digital rights organizations, even if they're non-profit, in collaboration with industry and with sometimes even government stakeholders, in order to like serve as a model law, almost to say that if India does get a privacy law, these are the things that it should contain. These laws, both of which from both CIS as well as the IFF broader campaign, are available in the public domain and anyone can sort of look at them. But the impact that these like pieces of model laws or regulation have had on final sort of like draft text of the law, which the only one that we've really seen in detail is the 2018, now 2019 draft of the data protection bill, aren't anywhere close to as like reflective of some of the great progress that was made in civil society efforts towards modeling India's privacy law. So that's like on general historical context, what's happened in the past, and some sort of insight into the political actors as well. I think that, like, secondly, I would like to cover a little bit on what the 2019 draft of the Personal Data Protection Bill in India does talk about, what's good, what's bad. And like fundamentally there, the law, as for some like almost like both political, more like geopolitical context, is very much seen by some players as a way in which India is trying to carve its fourth path, right? Like, so there is the path of the United States in data protection and regulation, where there is no federal privacy law, and there is a much more laissez-faire attitude towards what companies should or should not be able to deal with data, though that's rapidly changing in states like California, as well as Colorado, have some very great privacy legislation that's already been passed, and in many cases is being implemented. But that's nothing still at a federal level. There is the European Union approach, where the General Data Protection Regulation, which is arguably the most famous privacy law in the world, and almost certainly the one that has had the most wide-ranging impact on like cookie consent notices that you all see, and generally how large technology companies process data, is an approach that is has much more sort of like granular obligations and has high-level principles that have really set a benchmark for many parts of both the industry as well as the world. And finally, there is the Chinese approach, where there is a greater deference given to non-state, like just to the state in the running of data protection, like in general, and specifically with regard to things like the access to government data as well. Now, so the reason for like all of that, and like that, all of this is really just tied into that GDPR inspired point, is that India hopes to set a fourth path, right? Like India really wants to come to a scenario where it takes laws and regulations and like picks and chooses from these three different models to create a new path for sort of an emerging economy like India that can sort of both support its development goals and its innovation outlook, but also maintains the balance with regard to like state access to data and then generally like national security considerations as well. And those are the things that you really tend to see replicated in these two sections that are there on this slide, both with GDPR inspired as well as with the scope for improvement, right? Like the law in India contains some very strong obligations on private companies. There are many obligations that even the GDPR does not impose upon individuals, such as, for example, sometimes being mandatorily subject to audits, being mandatorily required to display your trust mark scores on your, or like your, almost like a trust score that says, as a company, this is what an auditor or the regulator has rated your data protection practices as. And things that like are frankly do not exist in any other data protection law that if they were to be implemented and in collaboration with industry can almost certainly lead to a scenario that does create much better awareness about privacy for Indian residents and Indian users. It also has a very good data protection authority, which is the regulator that is established under a law in order to implement it, right? So some of you may have heard of the Telecom Regulatory Authority of India that regulates telecom networks and the television sector. Some of you may have heard of SEBI, which is the Securities Exchange Board of India that regulates the financial markets. There's the Reserve Bank of India, which regulates banking and financial and monetary policy, more monetary than financial as a whole, right? So all of these are things that fundamentally speaking are regulators, and data, because of the fact that it's such a cross-cutting sector where every sector that we've discussed in the examples of regulators all contain some very, like, I think, interesting examples of sectors where data is like a very intrinsic part, end up being things that the Data Protection Authority in India will have to regulate, right? So that involves setting up new offices, hiring staff. It's a quasi sort of like both regulatory as well as adjudicatory body. So the Data Protection Authority under the law can investigate you for a data breach, as an example as well, and like fundamentally go into like I think some very interesting ideas in terms of how administrative law in India works. The standards that it places for consent and for the processing of data, something that Vrinda, I think, like in passing touched upon, and we can get into those principles for like in the discussion part of this conversation, are also actually pretty good. Some of them are certainly inspired by the GDPR, but like it both goes like one level higher in terms of creating higher obligations for like private entities, but there are also certain instances, and they are in the scope for improvement section of this slide, where they can be better for the government as well. And finally, it does subject and allow, like very similar to how many financial markets work, like data processing, like outfits to be subject to audits, right? So if you are, say, a credit rating company that assigns people credit scores, then you could be audited for whether you are following like the correct provisions within the data protection law. So all of these things are like a pretty strong message. And I think for the example that they would set for much of the world, as an example, more countries don't have data protection regulation in the world than those that do. And India is one of them that currently does not, in a meaningful way, at least apart from the rules that we discussed earlier. This is a pretty good standard. And like there are ways in which we should be pretty proud that we've managed to like do like some of the things that we have under this data protection law. But there is, as always, scope for tremendous improvement in many aspects as well. One like pretty prominent aspect and one that like Carnegie India has done some like I think fantastic work on is the idea of data localization and data transfers, where the flow of data between countries is something that all data protection regulation in some form or the other regulates, but India has particularly like harsh provisions that would at some level make sure that certain data can like never leave the country, which makes sense in a limited extent, but the law leaves pretty vague and open. But many other kinds of data that you would need active permission for before really sending out of the country. And that has had some digital trade implications. It's something that's become a bit of an issue in negotiations with both the United States as well as Europe. And in general is one of the sort of parts of the law that will be the most closely watched when its third, hopefully final draft is introduced in the parliament later this year. The second, and arguably, I think the place that deserves the most scope for improvement, and it's something that like we can talk about again in the discussion section, are the parts around government exceptions to data. So one of the key things within India's current draft of India's data protection bill is that the government can exempt any part of itself from any part of the law. And what that means is that you can say this agency, say the RBI, doesn't have to follow the data protection law. It's not, it may sound like a sort of preposterous idea, but for example, UK's data protection law actually has an exemption for the Bank of England for certain provisions of the law. So many governments tend to do that for financial regulators. But more importantly, it also poses many risks for law enforcement agencies, intelligence agencies, the access to sensitive databases such as those surrounding the Aadhaar and other forms of government identification. That all create some very tangible risks that the law leaves very wide open without any restraining sort of like function. The last draft of the law, as an example, also has this provision around user verification and how platforms are supposed to be able to like verify their users. But this is an example of a provision that, because it's also present in the new intermediary liability guidelines, which were laws that regulate online platforms and digital media entities that were passed in February of 2021. This provision is now already present there and was in that regulatory framework, and it's quite unlikely that it will now be present and hopefully in the final version of the law, because it doesn't make sense to have like 2 points in like the same point in 2 separate laws. But when it was a part of the law, it's an example of some of the feature creep that is present within the data protection regulation, and why some of those things probably deserve to be in different sort of regulations. And finally, there is the provision around independence, right? Where the Data Protection Authority, which I spoke about earlier, is fundamentally very, very important as an entity. And right now, its members will completely be appointed by the executive within the Indian government. The original draft of the law had like judges of the Supreme Court, like the Chief Justice, for example, and other entities from across the political spectrum. And society and in society in general, who could be nominated to run the Data Protection Authority, but that's been completely limited to the executive. So if you can imagine, if there are as wide exceptions as there are for governments, and all entities who will enforce those exceptions against the government are also a part, are all selected by the government, that there is a little bit of a sort of like oxymoronic scenario where it's quite difficult to imagine how some of these provisions can be enforced effectively against some of the most sort of egregious violations that take place in India. So that's a high-level overview of the draft PDP bill. There are many things that Vrinda's covered. I've covered some more, but like this is definitely a part that I'm sure that we can discuss in the sort of Q&A section that's about to come up. Finally, on non-personal data, the idea of non-personal data as a sort of concept is one that's quite new in India. It's one that many entities around the world are dealing with. So to start off, what is non-personal data? Anything that is not personal data is non-personal data, according to like India's sort of like outlook. So anything that can't be used to uniquely identify individuals and doesn't have the characteristics that Vrinda spoke about, such as, for example, names and are likely not are personal data, but are not sensitive personal data. So similarly, there are things that provide insights at a sort of city level, or almost to say at a high level, that don't involve the information of individuals, right? So for example, the top 100 products that a company, say like Amazon, sells in India, or the top 100 products that Amazon sells in your locality, where one of any of the attendees on this call reside, are all examples, both at a very high level and at a low level, of non-personal data, which are insights that are derived from individual personal data, but can't directly be attributed back to specific individuals, though that also is a sliding scale. And it's sort of beyond the scope of this discussion as to like whether it's actually possible to have truly anonymous data or not, but like there is a presumption at least that there is a category of data such as like traffic insights, for, say, from Uber rides, or traffic insights from Google Map navigations that millions of users in India do every day, are all examples of aggregated insights that are or serve as non-personal data. So India's approach to non-personal data so far is very much to treat it as a national resource, and to treat it in a manner that says that it is the collective like property almost of the or is a public good that should be balanced and administered by the state wherever appropriate, or otherwise by impacted communities. At its core, it's an idea that is spreading all over the world. The notion that merely data protection is insufficient to impose or to redress the power imbalance that exists between like very large technology corporations and individual entities is one that is certainly present. In many countries, the European Union is considering it, and many other countries are too. But India, I think, has gone a couple of steps further in almost looking at like non-personal data as this idea of forcing the transfer of data from entities that originally conducted to places where there is more value. And this broader approach is one that like we, like I think in India in general, are one that can clearly see some tangible benefits for, but also some very clear harms too, right? Like the benefits are, it does seem on the face of it like a nice way to like encourage competition in the sector, share some data with startups, and suddenly there's magically going to be a ton of innovation in the country. But there are risks to how it's implemented. The fact that like non-personal data can also pose privacy risks. So for example, if I can find out that, say, among the top 5 products in a particular locality are say religious books from a particular religion, or books that like show that people in that locality have a particular proclivity, that's an indirect insight that can very easily be weaponized against marginalized and vulnerable communities at an aggregated level that like India's framework doesn't really talk about too much. Then there is finally also this idea of like community data, which says that data should be managed by the community. So hypothetically, if you are, say, an indigenous group that lives in a particular region in India, and there is information about that region, then that information should be shared with you as a community so that you can do what you want with it. Again, in principle, this seems like an idea that should be engaged with, and indigenous rights and access to data is certainly an issue that I think India has tremendous like opportunity to really like push the needle forward on debates on that front. But currently the terminology around community is also very, very vaguely defined. So some of these things are all things that are present in reports. So like there is a committee of experts that's been established by the Indian government that's also been working on non-personal data. And ultimately, I think the law that may be framed under this is at least a couple of years away. So we will definitely see more progress on the data protection front before there is a law that is passed and binding on people on non-personal data. But the broader concepts around non-personal data, such as sharing it between players, encouraging it to be used for like local innovation and broader idea of data sovereignty, is definitely one that's like quite prevalent, and one that we should see like cropping up quite frequently over the coming months. And very quickly, therefore, I'm going to use the last maybe like 2-3 minutes to really talk about like what are some of the trends and expectations like from the space, right? Like the first at a very high level is that regulation is only picking up. Both the quantity and hopefully the quality of the laws that we're seeing in the space are picking up, and the rate of implementation of many of these proposals remains a concern, because the fact that we are a country that has over, by last count, I think between 700 to 800 million people on the internet but don't have a data protection law is like a little bit of a travesty. But I think the outlook or the ultimate opportunity like that remains there is great, and it's wonderful that like there is a lot of progress that's taking place on that front. The second is like this idea of data sovereignty and the supremacy of the state, which says that it's the state that decides what is good for its people, and it's the state that should be deferred to with regard to both access to this data as well as forcing private entities to comply, is very much a motivating factor in India, and it's something that is motivating many of the provisions that we've spoken about, but also this broader narrative of data being like the new oil, which is one that like I personally think should be pushed back against, because data, but like framing data as a resource makes it very hard to provide like constitutional rights to that resource, right? Like, because what you have to do is you have to protect the ability of people for something that is inherent with them, but you are protecting it via something that you're treating as property or almost as a resource. So that conflict between data as property and like fundamental rights of privacy and protection is one that's very like constant and tenuous in India, and is one that I don't think that we're really going to solve anytime soon. So it's definitely a trend that we should watch out for. There are many ancillary developments like that we haven't spoken about at all. There is something, for example, called the DEBA, which is the Digital Empowerment Architecture, and Health Stack, which is a set of like proposals by the Indian, by like ISPOT and like government lobbying / advocacy organization, and like the Ministry of Health and Information, that all contain very, very interesting concepts around the idea of consent, the idea of data transfers of common formats, of interoperability, and many other things. And I think that like some of them are slowing down because people are waiting to see how a data protection law may look first. But after that, it's quite likely that we will ultimately end up seeing a scenario where there will be very rapid implementation of many of these proposals as soon as like we have a law. So we should be sort of prepared for that. Overall, this is all to definitely say that like the final outcomes remain to be seen, but like anything that India does on this front, in many ways is going to be better than status quo, where we don't really have many of the protections that are fundamental to being able to allow people to live their lives, especially online, with dignity. In many of the questions, for example, that I've seen in the conversation in the panel so far, and that I'm sure we'll talk about, deal with this question and ask like questions about risk or why some of these pretty egregious activities keep taking place. And many of those things can be diverted to the fact that we don't have a good data protection law yet. And the sooner that we have one, the better it will be. But it's also like wise to keep in mind that like having a data protection law might just end up entrenching some of like the powers, say, around surveillance and like the deference to like state actors with regard to access of data within like final binding legal positions. That of course is good in a way, because then they can be challenged in courts and can be like contested, but also bad in a way that once that happens, like we might just see many of the activities that are worrying that are taking place under the current regime of very weak data protection in India actually become more exaggerated when they're officially endorsed by law. And finally, there is this idea of like India trying to like set an example to the rest of the world, and the fact that many countries are watching and learning is definitely like a very concrete opportunity to get inspired by those things and those conversations outside, but also that India clearly also has an opportunity to inspire people around the world in equal measure for how to make or set up a good data governance framework. And it's bound to be a very exciting time over the next coming years. So yeah, those are my thoughts. And I think that we can maybe hand back to Arjun for both moderating and for answering like the questions that we have in chat.
Actually, I think you guys can go ahead with the conversation and answer the questions as you go. If anyone wants to come in, please feel free to raise their hands, or if you'd like to call on anyone who's already asked a question, we can let them in as well.
Maybe Udbhav, what I'll do is I'll post the questions in the Q&A to us, and we can kind of decide, you know, we can maybe either take turns to answer them or like sort of build on each other's answers. Does that broadly make sense? Udbhav, I think we've lost Udbhav for a second. Maybe you'd like to start answering some questions. Yeah. I think we may have lost Udbhav. So I kind of maybe we'll start with Shahana's question. How do we make sure consent is informed and properly understood, particularly in the Indian context where people may not understand language or implications? So I think this is a really important question. And there is this whole idea about this. So the PDP bill itself recognizes an idea called privacy by design, which is the idea that you will build in when you're formulating, for instance, your privacy policy and your general data processes within a company. You will build in ideas wherein you're making it easier for the people to understand what you are trying to explain. So your privacy policy is, easily explained You're making sure you're following the requisite data minimization practices. So this has sort of led what we've seen in the EU where the GDPR is there. This has led to a situation where you now have companies focusing a lot on the design aspect. So for instance, how do you present information to customers? How do you make it easy for them to understand what they are consenting to? And this is a whole line called like UI and UX, right? So like designing the layout, for instance, of the mobile app. And this some of the tools that are used that can be used by companies that want to follow privacy-friendly policies could be things like, if you see on your iPhone, they're called just-in-time notices. So when you are sharing a certain information or when you're accessing certain location, your phone may tell you, are you sure you want, do you have settings? Have you given settings to your camera or to the location? Or when we all sign into Zoom, it says, are you okay with consenting to both your microphone and your audio recording? So they're asking us at the point we are accessing the service and not merely at the time we downloaded the app. So you give one set of consents when we download the app. So when we downloaded Zoom, we would have always said yes to the privacy policy and yes to the terms of service. But a good privacy design element is that at the time we are sort of accessing the app, it's asking us, give consent to your give consent to audio, give consent to video, and then we share that information. It's also about things like explaining privacy, like so not having very jargony language, explaining it more simply, using as much sort of like as if you're trying to explain it to a child, right? So you have a short privacy notice where you explain things simply, and then you can have your more detailed, more legalese kind of privacy version, which is which is then linked to this shorter privacy version. So I think some of the ways in which this can be done is through design principles. Having said that, I think we have to recognize that consent consent fatigue is a real problem. Consent is a real problem in the sense that there are many studies that show if you actually start spending time reading each privacy policy, it'll take billions of hours. And that even when we read, it's actually very difficult to explain and understand that privacy policy itself. So there was a study that was conducted by the National Institute of Public Finance and Policy, where they gave privacy policies of 5 companies. I think it was Google, Paytm, Flipkart, WhatsApp, and maybe one more, to even law students, right? So law students who have an understanding of the law. And they found even then, the law students were not able to explain and answer all the questions of what the privacy policy did. That is why many people, people like Rahul Mathan have advocated for like a separate accountability framework instead of like just laying everything on consent and choice. But I think where the PDP bill has gone is to try and make consent simpler, to make it, to make sure that you don't have these ideas of bundled consent. So yeah, if that answers your question, Shahana, and if there's a further question, I guess, you can just type that in as well. Arjun, should I just keep on taking questions till Udbhav joins back?
Yeah, he'll be back in a minute or two. So maybe just one more question.
Yeah. So is the, it's Pavan's question, is categorization of sensitive versus non-sensitive data universal or standardized? Because this may vary with person to person. I'm not exactly sure what you mean by universal or standardized, but Pavan, if I understand your question, if your question is really the category of what is sensitive personal data is defined in the law. So things like your health data or your financial data are sensitive personal data. It will generally not at all matter who the individual or the data subject is, who is kind of, whose personal data is being processed. So the DNA of any of us, like if DNA samples are taken for any of us, that would constitute sensitive personal data. Our bank account details will constitute sensitive personal data, regardless of kind of the individual involved. The only place where I was trying to make the argument that context may matter, and this is again just kind of my interpretation, is when you look at the meaning of caste or tribe being sensitive personal data. So if, for instance, your name reveals, so as I mentioned in the presentation, your sensitive personal data, if you have data that's sensitive personal data, you have to follow additional obligations, primarily being explicit consent and then data localization. If you consider that name is sensitive, like your name reveals your caste and that becomes sensitive personal data, then that would mean that every company for any name that they give, they would have to take explicit consent every single time. They would have to store all the data in India, which would almost make the bill unworkable. So that is the only place where I would say context may matter. As I mentioned, the text of the law doesn't necessarily support this interpretation, but I believe that would be the reasonable interpretation to give, because when a court is looking at interpreting a law, they want to make it workable and harmonized. They don't want to make the law unimplementable. So I think, and Udbhav, if I'm answering the question, if you want to add to this, is the categorization of sensitive and non-sensitive data universal or standardized? Because this may vary from person to person.
So, I mean, I think laws tend to work in a manner in which they are sort of standardized. There are certainly like categories of data that are considered personal and sensitive, but there are also like, I think there is enough leeway in most data protection laws to like allow context to play a role, which is the manner in which a piece of data is interpreted, or the use that it is put to, also plays a role in determining whether it may, if it is a gray area, whether it is inherently sensitive or not. I think the example that you used earlier in your talk around caste and how that can be inferred from surnames is a good example of something that like typically is just personal data and isn't even like sensitive personal data, but there are certainly use cases and scenarios in which it's possible that a regulatory authority may ask for it to be treated in a special way, or ban particular interpretations from a piece of personal data because those interpretations may end up being sensitive. And I think like that's something that we largely have to wait and see with regard to how India's, like once the law is passed and the data protection authority is set up, how it can go around, how people can go around dealing.
I think this also means that we answer this other question that's been asked by Sudarshan, which is, my question is about the nebulous aspect pertaining to sensitive personal data. On treating a data sensitive or not, should one look at the purposeful approach that is focused on the intentions of the data processor, or should a context-based approach be adopted where it would be possible to draw conclusions from the data that might be sensitive in nature? I would believe that context is probably going to be more important than purpose or the intention of the data processor. Or the data fiduciary really the data fiduciary in this case, more than really what the intention of the data fiduciary is. I would imagine if there is any kind of doubt. So I think for most things, there would be no doubt that this is sensitive personal data, it's not. For things that are in the gray area, like this example that we were discussing, I think context would matter more than purpose. I don't know what you think, Udbhav.
No, I agree. I mean, I think it's there's almost no point to having data protection regulation unless it can account for such nuances and context, especially ones like that are unique, like geographical locations or countries like those in India. And I think that ultimately it's about how that context is interpreted, how it's like enforced, what are the ways in which both private actors as well as state actors are like somehow given the same sort of treatment when it comes to these like difficult questions, are some of the ways in which I think we'll see these questions being answered over the coming years. But it's also a scenario where like some of them may be answered in India, for example, for the first time, that will then set the precedent for how they should be dealt with globally in an open system.
Yeah. The next question, and I'll let you take this first, is the rule of storing data in India the reason that Mastercard got banned in India?
Sure. So it's a complicated, it's a complicated story. The answer is simple. There isn't a rule to store all your data in India yet. There is a general rule. There is a specific rule by the Reserve Bank of India that does mandate storing financial information within the country. But even that rule and its implementation actually has some exceptions that allows for the information to go out for a period of 24 hours before it's only stored here. It's something that took a fair bit of re-architecturing for many financial service providers to be able to comply with. And the specific reason that Mastercard was not allowed to onboard new customers was because the Reserve Bank of India was not satisfied with the audit report that was submitted to showcase compliance with the law. So they're now currently working on coming with a new audit, and they are supposed to share that with the RBI pretty soon. And it's not just Mastercard, but also players like American Express that have had similar sort of limitations posed upon them. And that's just an example of what happens when you try to create, I think, data localization measures that are actually pretty difficult to implement in practice and require radically re-architecturing how very complicated digital systems work. And those teething problems that I think we're seeing in the financial sector now are ones that many other sectors will face in the near future once India's data protection, the high-level law, passes as well.
Yeah, I think I don't need to really add to that, except to say what is, I think, interesting is to see how different localized. So we talk always about localization requirements that the RBI has ensured, but there are also localization requirements in the insurance industry. So the insurance regulator, the IRDA, also has certain localization requirements. And so it'll be interesting to see how all of these regulators will work together. The PDP bill is interesting in that it does require the regulators to speak to each other. So in that sense, it's an interesting provision of law where they actually do contemplate the regulators sort of speaking to each other and coming to a certain consensus possibly. So I think that is something we will almost have to see. Next question. Are there rules or guidelines to ensure simpler and shorter terms of use? Because these are mostly designed in a very complex and lengthy way. It almost compels the user to consent even without answering the terms, without understanding the terms. I think I sort of answered this in the beginning a bit when I was talking about the importance of privacy by design, which really is going to be a way of pushing companies to adopt easier policies. I think one other thing that I hadn't spoken of, but which may also be relevant, is you do see with significant data fiduciaries, so your really big companies, that they will have data auditors who may give them data trust scores. So maybe one of the factors that will emerge is like the ease of your privacy policy, the fact of, whether it's easy to understand, maybe one of the factors on which you'll get a star rating or a trust score rating. And so that might, the idea there is really, if I'm a customer, I see, one company's data trust score is say 9 and another's is 5. That inherently tells me without having to read everything that one company is more privacy protecting. And so I may be, in favor of accessing the services of sort of the more privacy protecting company. So that might also be a factor in pushing companies to improve their privacy policies and to make them easier to understand. I mean, having said that, at the end of the day, it is true that we live in a world with asymmetric bargaining power. Even if I understand all the terms of WhatsApp's privacy policy, it almost does not matter if I don't agree with some of them, because I still want to use the service. The other thing that's actually useful is this idea of really granular consent. So if you go, for instance, to your Facebook privacy profile settings, you will be astounded with the number of checks, tick boxes that you can fill, like that you may have already pre-filled, it may have been opt-in by default. But the kind of granularity of the options that you have on Facebook, as an example, maybe another way where if you are very, if you're very concerned about privacy, at least you have some control over where your data is being shared. Like, so I teach a course on data privacy with, with different students. And one thing we do is like, we go on Facebook's privacy policy and we actually see the different terms. And for most people, these are pre-checked, right? And that is, again, another issue of privacy by design. You should not have, and you cannot have default opt-ins. But what all of that means, I think, can be really interesting. And so these different factors may ensure how you get over problems of consent. And like, Udbhav, if you want to answer or add to that.
No, I mean, I think that was pretty comprehensive. Right?
Okay. So the next question then for you, they're sort of both similar, so I'm going to combine them. There is often news about leak of card details in bulk on the dark web, but the said company is not held accountable by the government or media. Is this because there is no legal liability? And then maybe slightly related, Google knows everything about us, like you search and the same pop-ups coming in it is a privacy invasion. If so, how can we stop this? I mean, so either we can take them separately or together, whatever you're more comfortable with.
Sure, thank you. I mean, I think on the first question, yes, it's because we don't have any legal liability. So the broader framing of that issue that you're talking about in particular are known as data breaches, which are when pieces of information are broadly available in the open web or otherwise publicly, or sometimes even being sold in markets on the dark web and things like that. So most good data protection laws actually contain an obligation that people must inform their customers when they suffer from a data protection, from a data breach, and also that in some regulated sectors, in some countries, there's even a requirement that you have to prove that you carried out the best privacy and security practices before you can be held not liable for it, right? So, for example, if your data got hacked despite you updating all your systems, having a good audit procedure, controlling access to that information, then it's possible that the company may not be held liable for it. But more often than not, data protection regulators all around the world, both under the GDPR as well as in the UK, which is the Information Commissioner's Office, the ICO, regularly, like almost on a monthly basis, fine companies for data breaches because they determine the fact that the companies did not carry out the actions they were supposed to protect that data as well as possible. So in terms of incentives existing within laws, both like penalties, whether they're financial or not, as well as positive incentives that say will give you a better trust score if you have better security practices are both good ways to counteract the rapidly increasing number of data breaches, because unless there is a legal obligation for entities to protect their consumers' data, apart from the idea that you will use consumer trust and people will stop trusting you and using your services, is one that many companies try to really use in the past, saying the market is our biggest sort of incentive, is one that hasn't really worked out. So it's clear that there is a need for a strong law that incentivizes not carrying out activities that ultimately lead to data breaches. On the Google front, and that's the second question, I think that there are multiple ways to answer that question. And at its core, it's the fact that, number one, privacy and data protection laws more often than not will restrain the actions of companies, but it's largely an issue of digital literacy when it comes to users enforcing, or doing something with the right that the law empowers them with. For example, it's perfectly legal for Google to show you pop-up ads, it doesn't show pop-up ads, but for Google to show you ads on the basis of your search history, because ostensibly you have consented to that when you decided to use the Google service. If you wouldn't like to do so, there are opportunities within Google to turn off advertising targeting, just like many other companies offer, or there is the ability, and this is something that we're starting to see in laws like with the GDPR, where you can actually take, if you believe there is an illegal act that is taking place or the consent that you're providing is insufficient, you can complain to a data protection authority, and they will then investigate Google and then determine what does or does not happen in that scenario. And that equally applies not just for Google, but for Facebook, for Twitter, for Pinterest, any or large online software company that you may use. It would equally apply, for example, to BSNL or Airtel or Reliance Jio, entities that sometimes show you ads and even on websites on the internet on the basis of your browsing history as an ISP, as an example. So there is definitely a very big gap between how much users understand privacy policies, like Vrinda alluded to, but also how much users know what to do when they think that their privacy is being breached and violated. And that's clearly going to be one of, I think, the biggest tasks that the Data Protection Authority will have to account for, right? Languages, general awareness among the public, it's definitely a problem, but the solutions, I think, lie as much in consumer awareness as they lie in legal enforcement.
I would only add to that kind of super comprehensive answer that it's not just also about having statutory protections, but about making sure that it works, that the law doesn't become defunct, that the regulator that's set up doesn't become defunct. So for instance, under the current IT Act, you have an organization that's called CERTIN, so Computer Emergency Response Team, which is actually tasked with dealing with security breaches. And they have sort of historically not really acted, they send some notice to companies, but they don't take any actions. They don't have a lot of power. So it's also about ensuring, because so much of the data protection, the success of any data protection law, and especially the Indian PDP bill, depends on the regulator. It's absolutely important to have an independent regulator, to have a regulator that has teeth, that's actually active, that also works on all of these issues. So that's really the only other only other thing that I would add to Udbhav's answer. Next question. You gave an example about sharing accounts with a chartered accountant. If the CA uses an accounting tool like Tally or QuickBooks to process my accounts, who is the data fiduciary and the data processor here? Where does the data loop end? So the CA would be the data fiduciary. The CA is using the accounting tool. So they are sort of entering into kind of a contract in the sense of for the use of certain software. And that contract, so Tally or QuickBooks in that case, the company that runs these accounting tools, would be the data processor. So under the PDP bill now, a data processor can only act on the basis of a written contract. That written contract with the data processor will have to have all the contractual obligations, the actual directions for use, how that data can be used. Under the PDP bill, data processors, because they have no direct relationship with the customers, their obligations are more restricted. So one of the primary obligations, for instance, is security. So they have to make sure that they also follow a lot of security practices so that there is no breach at their end as well. Because we've been seeing in a lot of these new cyber wars that a lot of the data breaches don't happen at the fiduciary levels, but happens almost at a sub-vendors level, not even at the vendor or the processors, but the sub-processor. So the data loop really is, of course, the data processor can further sort of subcontract. The idea is that there has to be a contract for each of these, relationships, so that there is a proper paper trail. Udbhav, do you want to add to that?
No, nothing in terms of the substance, but just as an example, I think that In practice, the example of the chartered accountant and that flow of data is actually how in real life that plays out, right? You do share your data with many individuals without necessarily always entering into like formalized agreements with them. But what data protection laws tend to do is that they create obligations in general as well. So for example, even if there isn't a contract between you and say another individual, but that individual is performing that role anyway, then in that case, like you can, for example, if you imagine you give your accounting information to a chartered accountant, he files your taxes on Tally, everything is fine. And then, but he does this on Tally online and Tally suffers from a data breach, right? In that case, it's Tally that's the problem, not the accountant. Or if your accountant decides to sell that information to a credit scoring company so that he can, or she or they can make some money, then that's another instance in which the accountant is liable, right? Like, so that loop of obligations with regard to data in many ways is actually never ending. As long as data exists, someone or multiple people are always responsible for it. And that's actually the primary purpose of the data protection regulation, to make them all treat that data in a responsible manner.
If there's one takeaway that Udbhav and I have, it's that we need a data protection law for all of these problems. The next is actually an answer I'm going to confess I'm not entirely sure. So I'm going to hope Udbhav knows the answer. I'm going to put him in the spotlight. Is data allowed to be booked as an asset in companies' balance sheets? My sense is yes. But I actually am not aware. Udbhav, do you kind of have more knowledge on this?
I mean, under like data protection laws, like no law says whether you can or cannot. Very often there is like a value assigned to services that companies provide on the basis of data. So for example, if you are an advertising company and you target people on the basis of their data, your advertising service can be valued in a certain form, but intrinsically and in and of itself, it's very rarely that data is assigned like independent value as an asset. It's almost in the use cases that which it is put to and the services and products that rely on it that get assigned that value. Building off on that point that I made earlier in my presentation about the problems that arise from treating with data as property, as something that is an asset and can be assigned values to, is that it becomes very, very hard to then also enforce constitutional protections upon interactions with that data. Because the moment you start treating it as a property, it becomes something that people can sort of trade and give away and sell and do many other things, which while it sounds like that's already what is taking place, that's actually not what is taking place in most interactions. Ostensibly, data protection law exists because your data still is ultimately supposed to be your data, which is why you're supposed to be able to delete it whenever you want to, be able to ask a copy for it whenever you want, ensure that you can port it to another entity whenever you want. And all of these things showcase that the ultimate owner of that data is you. Insights on that data that may be derived from it sometimes may belong to other companies. So in that case, I can't imagine any sensible company wanting to list, 4 petabytes of data as an asset that it assigns a particular piece of value to, because A, data protection regulators would really want to look into that, and B, I don't think that that would do anything per se to help the valuation of that company. It's what that company would do with that data that is, I think, more interesting.
Yeah, thanks. Could you draw some insights on the Pegasus case? I'm not exactly sure what the question is about, but maybe I'll just say kind of what I've already said publicly, which is that I think it's important when you look at a case like Pegasus to distinguish between what is like legally authorized surveillance, so what is permitted under the Information Technology Act under Section 69, so interception, monitoring, decryption, and what something like Pegasus does, which really essentially, I would argue, is hacking, that it kind of goes into your computer, goes into your mobile phone. With the iPhone, it can gain root privileges. It can actually access your videos, it can access, it can turn off on things. So the way what Pegasus does make it, according to me, hacking. There is no national security exception for hacking. So while surveillance is permitted under Indian law for national security purposes, hacking does not have a national security exception. It is an offense. So I think in terms of insights, what I think Pegasus tells you is not necessarily that you need law. I mean, I think we have enough legal framework. I think what it does tell you is, in general, you need to ensure that you have, I think what Pegasus does, it brings again the question to light about the importance or the prevalence of surveillance all around us, whether legal surveillance, illegal surveillance. It speaks to the need of surveillance reform. So I've argued about this kind of extensively before. We need to have judicial oversight of surveillance actions. Currently, as per 2014 data, you actually have 7,500 to 9,000 interception orders that are passed by the central government every month. These are supposed to be reviewed by a 3-member executive review committee that's comprising the cabinet secretary, like that's chaired by the cabinet secretary. It has the law secretary and the electronics and information technology secretary. You're asked, that means even as per 2014 data, they're looking at 15,000 to 18,000 surveillance orders every 2 months. There is no human way in which you can actually apply your mind and have due process. So I think if what Pegasus tells you, it's that we really need to relook our surveillance infrastructure. We need to bring our intelligence agencies, we need to speak about intelligence reform, bring about some element of parliamentary oversight and statutory accountability of intelligence agencies. So I think, yeah, I was not exactly sure what the question asks, but these are the things that I think would draw insights. Udbhav, do you want to add?
I mean, yeah, just one small point, which is that I think even if we had a data protection law, like the variant that does exist in its latest draft form, it wouldn't really change anything about things like Pegasus existing, right? Like there are European governments that have been accused of using Pegasus and they are bound by the GDPR. So I think the fundamental issue behind Pegasus is that of like procedural oversight of the actions of law enforcement agencies and intelligence agencies and governments as a whole, right? And how independent that oversight can be made. If and when utilized in a targeted manner, like the very idea of government hacking is one that I don't think there's any law that like completely in the world that says the government cannot hack systems. But just like there is no law that says governments explicitly cannot perform many things in the like name of national security. But I think it's the checks and balances that exist that question the government's ability to do so at the right instances that are essential to make sure that if such tools and technologies are utilized, they aren't utilized in the sort of like very broad and disproportionate manner in which they very clearly are right now.
I would actually also just add to that, that even if we have the Indian PDP bill, the PDP bill essentially exempts law enforcement agencies from the entire application of the act. It's something we've not spoken about. It's one of the most controversial aspects of the bill, clause 35 of the PDP bill, if anyone is interested, and it actually exempts the entire application of the act for like national security purposes, etc. So I'm not sure having a data protection law would make any difference in this case. Okay, next question. Does data sovereignty and data localization, are they one and the same? Udbhav, do you want to take the first go at this?
Sure. I mean, I think data sovereignty and data localization are related concepts, but are fundamentally different. The notion behind data localization is probably a manifestation of data sovereignty, where data sovereignty is the idea that a nation state wants to control what happens with data within its borders, as well as to whatever extent possible outside its borders. And one way to do that is to make sure the data cannot leave. And that is like enforced via data localization. But there are many other ways in which like entities enforce data sovereignty as well. One could argue some of the things that say are happening between Amazon, Flipkart, and e-commerce platforms in the Indian government is also a form of data sovereignty, because the government does not want to give them the access to data and insights that like lead to domestic traders being disproportionately like hindered, right? So that's a manifestation of data sovereignty, I would say there. And like the European Union has also said that like data sovereignty may be about infrastructure, right? Making sure that you have enough data centers, making sure that you have enough cables that connect your country to other countries that are not under the control of foreign governments or foreign companies but belong to the country itself. So I think like the idea of data sovereignty and the data idea of globalization like need to be balanced, and that's the debate that is essentially, I think, playing out in the public domain.
Yeah, I would only again like just add to this that another way potentially like the reason we have data sovereignty. So as Udbhav pointed out, data localization is a more intense version almost of data sovereignty. But data sovereignty also explains why we have agreements between countries when they talk about cross-border sharing of data, right? So when data is transferring from one agency to another, it's because both countries, like because of the idea of data sovereignty, you need to enter into a formal arrangement when you're transferring data across borders. Or why law enforcement agencies can only, like, so Indian law enforcement agencies require MLAT. So, you have these mutual legal assistance treaties to get data that's stored in the US if you want data from the US. So that's data sovereignty also explains why you have this kind of cross-border flow of data and why you need agreements for that. Okay, in your opinion, what is the ideal role of the state in data protection and regulation? On the one hand, prominent state intervention poses significant dangers, as unlike private players, the state wields a coercive power. However, more laissez-faire approach has its own pitfalls. So in my opinion, the ideal role of state data is you do need a regulation in this space. I think we have realized that a laissez-faire approach when it comes to data does not work. Even for other reasons that we've not discussed today, which is, the asymmetry of bargaining power between an individual and a market. Like, it is never going to be an equal market. You also have ideas of, bounded rationality. So ideas, we've discussed this a bit, the fact that one doesn't necessarily understand all the privacy policies. So if there was no requirement for privacy policies, for instance, to be simply put, there would almost be the fact that we are not necessarily capable of understanding the consequences of all our decisions because of the complexities means you sometimes do need the state to come in and say you have to follow certain security safeguards, for instance. I, as an individual customer, have no idea what are the requisite or commercially acceptable security safeguards. So I do think the ideal role of a state should be to have a data. I think we do need a data protection legislation. There are, of course, questions whether you need a stronger form of data protection, such as the GDPR, which is criticized by many companies as like stifling innovation, or whether it should be a more sort of weaker version or like a more soft touch approach. I think in India, given that we've not had any data protection legislation, I think when we're drafting one, it should be something where the state has decent control. I do think, though, what is very important, more than the role of the state, it's to ensure the independence of the DPA. For me, that is actually much more important and a more important question to ask, because what the current PDP version of the bill does is that the state government has exclusive power to appoint the DPA. And given that the state is the biggest data fiduciary of them all and is then subject to the data protection regulation, I think that is actually the more interesting question rather than how much is the role. It's what is the independence of the DPA, and hence what is the function, like what will be the efficacy. The reason the GDPR works, or you have the ICO in works, is because the regulators, the ICO in England, are very, very active. Some might say too active, but there is no question that the privacy of citizens is being protected. Udbhav, do you want to? Okay, next question. How many checks and balances can be practically imposed on the functioning of these companies that create applications, shopping, online games, news requiring our data? Given the exponential rise in the number of apps, how can their infringement on privacy be controlled feasibly? Do you want to take that first? Do you want me to repeat the question?
No, because I think the answer is the same. We need to have a good data protection law. The only real way in which I think many of these fundamental problems in terms of not just their rapid proliferation, but also the fact that I think much of the exploitation that takes place that is related to data in India are all things that also stem from a lack of awareness, not just of consumers, but also like from developers and technology practitioners, right? Like the idea or the ethos behind doing things like privacy by design, ensuring that there are remedies available to users if things go wrong, looking at that intrinsic role that security plays in protecting privacy are all not things that happen, I would say, like automatically. They're all fundamentally things that only kick in once there is a culture within the technology sector, within a country, to treat these things in a particular manner. So I think that while data protection laws can provide a lot of that coercive, legal obligation type push, it's much, much more effective to actually look at what are the ways in which an ecosystem can be empowered to deal with those things in and of itself, which also is one of the duties of the data protection authority, I think.
And I would also add that consumer behavior really can change things. So, you have seen WhatsApp introducing some privacy improvements because, of all the sort of general controversies, its comparison to Signal. So WhatsApp now has disappearing messages, for instance, which is not something that they had earlier. Now, one doesn't know whether it's directly in response to Signal or not, but I think when you also have a lot of products that are a bit interoperable, and when the cost of switching is really low. So, I think the problem with Google and DuckDuckGo is that not many people use DuckDuckGo, but because Signal really took off, I think that did push WhatsApp to improve some of their features. So I think that is consumer behavior at the end of the day is also really going to become important. So we have 3 more questions. Arjun, we have time for 3 more questions?
Yeah, sure. And if you're willing to answer them, I'm sure people will wait.
All right. Okay, let's do it really quickly. So 2 of them are on AI. So let's start with that. How can law and policy deal with unequal representation in data sets and resulting inequality in consequences, issues like algorithm bias? Is that something that is being dealt with in the Indian context? Should companies be obliged to reveal what kind of models they run on the data? Suppose a scenario arises where my name, which is collected as personal information, is put through a machine learning model to assess my credit worthiness. Say the model is inherently biased against people of certain castes or surnames due to data bias, and it is contributed to a decision. How do we understand context in this case? Yeah, Udbhav, do you want to kind of take those questions, or I can take them, whatever.
Sure, no, I'm happy to give a very quick, super short answer. And the answer is yes, the data protection law will account for some of these things, but nowhere close to the extent that they should be accounted for. Regulation around artificial intelligence technologies and machine learning in general is at a very nascent stage. And for example, the European Union is thinking of creating categories of use cases, where in some cases it is illegal to use artificial intelligence and machine learning. And in some use cases, it is subject to very high audit requirements and public disclosure and transparency requirements. And in some cases, people can keep doing what they're doing the way that they're doing it, right? So I think the ultimate answer lies in we will likely need a dedicated law to deal with some of these things, but any such law will likely use the data protection law as a foundation. So that's the thing that we should do first. But after that really comes into force, I think there is some small things a data protection regulator can do to prevent some of these more obvious harms. But ultimately, this deserves a separate piece of legislation, and that's something that I think we're seeing develop in Europe right now and is likely to sort of proliferate around the world.
Yeah, I mean, I think you're also going to look at things like algorithmic accountability, etc. Even New York and the US, there's some developments around that, and some of that is just also understanding what is the basis of decision making. So the AI black box that sort of exists, understanding that. When it comes to law enforcement purposes, things like facial recognition technology, and if it's going to be used in the criminal justice system, I think that will result in faster regulation or faster judicial decisions. So where courts will say that an AI-based model cannot be used maybe in a criminal justice department. So I think that is something we are going to see develop in maybe the next 5 years. Final question: who owns and controls the dark web? Can it ever be controlled and regulated? I feel like that's a very philosophical question. The answer to which is probably it cannot be controlled. It's outside the legal framework. So I'm not sure anybody owns or controls it. But yeah, Udbhav, if you want to give a maybe better answer than that.
No, I mean, the dark web is controlled and regulated in various ways. You regularly have takedowns worth billions of dollars that law enforcement agencies coordinate across the world. It's a cat and mouse game between law enforcement and entities that run illegal operations, but one must be very clear in that the idea of the dark web or connections that run on Tor is not in and of itself inherently illegal. It's just a privacy protecting way of doing communication. There are as many journalists that break some of the biggest stories in the world on Tor as there are a lot of the nefarious things that we see on it. So I think just end-to-end encryption can both be controlled and regulated, but that doesn't mean it should. That's also something that I think should equally apply to the dark web as well, where there are some bad things that happen there and there are ways to counteract them, and those are being done, but that doesn't mean that it is inherently a bad thing, and it has many privacy and anonymity benefits that I think are definitely good things.
Great. I think we've answered all the questions. I have had the ability to choose which questions I'm going to put to Udbhav first and which questions I'm going to answer first. So thanks, Udbhav, for agreeing with that.
So I guess if either of you have any closing remarks you'd like to share, otherwise we're done. And thank you so much for such informative session. I mean, I've been working on data for 2 years and I learned things, so I'm sure other people did. And thank you everyone for attending, and we hope to see you at the next session for Building an AI Nation.
Thank you.
Thank you so much for having us.
Bye-bye.